City of Akron versus Derek Starks. Mr. Starks' counsel has waived his appearance today, so we're here from the City of Akron in this case. You may proceed. Each party will have, well, you're the attorney, so there's no, obviously no time to reserve for rebuttal, but we are being visually and audibly recorded to be posted online, so try to get behind the podium as much as possible. We have your regular briefs and we're ready to proceed with you.
Good morning, Your Honors. My name is Shauna Smolik on behalf of the state of Ohio. The assignment of error before the court today is relatively straightforward. Appellant, Mr. Derek Starks, seeks to override his speeding and OVI convictions on the argument that his trial counsel committed ineffective assistance of counsel in not challenging the basis for his initial traffic stop, Mr. Starks, and the probable cause for the OVI arrest with a motion to suppress. Mr. Starks really fails to lay out substantive arguments to meet the ineffective assistance of counsel standard here, and for the reasons that I'll state, we respectfully request that the assignment of error be overruled and the judgment of the trial court be affirmed. What I'd like to do today briefly is just go over the ineffective assistance of counsel standard and why it's particularly difficult for Mr. Starks to meet the standard in this case where a motion to suppress is involved, and then go through the basis for the underlying traffic stop and then the OVI arrest, and explain why Mr. Starks has failed to meet the standard with regard to both of those. So to begin with, the ineffective assistance of counsel standard from the United States Supreme Court's case in Strickland v. Washington is a two-pronged test. First, requiring the appellant to show that the counsel engaged in such serious deficiencies as to be outside, such that counsel was not acting as counsel guaranteed by the Sixth Amendment. This is a particularly high standard, and there's a strong presumption that the actions of counsel were within the bounds of reasonableness. And even if the appellant can demonstrate this, the appellant also must show that there's a reasonable probability that but for the deficiencies, that the outcome of the trial would have been different. If the motion had been made, that the outcome would be different. And here, Mr. Starks has not met those, particularly when the alleged ineffective assistance of counsel is a motion to suppress. As this court has noted in State v. Davis, it is difficult for the appellant to meet this burden because there was no motion to suppress at below, and so there was no suppression hearing at which evidence about the basis for these stops could come out. And so unless there is some apparent basis in the appellate record that demonstrates that such a motion would have been granted, appellant cannot succeed on this type of claim. Now, first turning to the basis for the traffic stop, it requires the reasonable suspicion based on specific and articulable facts that the defendant was engaged in or is engaged in criminal activity. Here, Trooper Jared Hasler had that reasonable suspicion based on observing Mr. Starks speeding 50 miles per hour in a 35 mile per hour zone. Mr. Starks' own brief admits that this standard was satisfied, noting that observing the violation, as Trooper Hasler did both visually and with radar, constitutes a prima facie violation of the statute. And this prima facie evidence is higher than probable cause standard, which does not have to be more likely than not, and that's even more higher than reasonable suspicion. And so Mr. Starks is admitting that the standard was satisfied in this case, and so it cannot be shown that not making a motion to challenge this basis was a deficiency, and also that such a motion, if it had been made, there's not a reasonable probability that it would have succeeded or changed the outcome of the case. In addition, there are other independent bases that may have satisfied reasonable suspicion. There was a cracked windshield that Trooper Hasler observed that also satisfied reasonable suspicion, and there was also a crack in Mr. Starks' windshield that also may have satisfied reasonable suspicion. We don't know the size of the crack because there was no motion to suppress in a suppression hearing where some of that evidence would have needed to come out. but it well could have served as a third independent basis for reasonable suspicion. Turning to the probable cause for the OVI arrest, probable cause is based on the totality of the circumstances that a prudent person would be warranted in believing that the offense had been committed. Here, that totality of circumstances clearly indicated sufficient evidence for probable cause. Trooper Hasler observed Mr. Stark speeding very late at night around 2 a.m., going 15 miles per hour over the speed limit. Upon stopping Mr. Starks, Trooper Hasler observed moderate odor of alcohol as well as bloodshot and glassy eyes. Upon speaking with Mr. Starks volunteered to Trooper Hasler that he was coming from a bar and that he had had 3 to 4 shots of tequila at the bar.
That doesn't sound like somebody that's intoxicated, though, that he automatically has enough presence of mind and functioning ability to say to the trooper, look, I'm Chris, come clean, I've been at a bar and I've had 3 or 4 shots.
Well,
No slurring of speech or anything.
sure, while there wasn't slurring of speech, it doesn't necessarily, I think, indicate that he was not intoxicated. It may be someone trying to say, I'm not that intoxicated. But in addition to that as well, and the odor and the glassy eyes, there was also a field sobriety test that Trooper Hasler then performed on Mr. Starks, or asked Mr. Starks to perform, and based on those tests, those 3 tests, there were numerous indicators of intoxication, including performance on the horizontal gaze and nystagmus test that indicated, according to Trooper Hasler's training, that there was an 88% chance of intoxication from that. And so I think based on the totality of all of those, especially with those field sobriety tests, that there was sufficient amount of evidence. This was a similar amount of evidence as was present in State v. Penix, the 11th District case, in which the 11th District found that there was sufficient probable cause. Now, Mr. Stark's argument seems to be by implication, solely by implication, that the field sobriety test should have been suppressed and that without that there would not have been sufficient probable cause. Now, Mr. Starks doesn't actually make this argument and doesn't actually provide a basis for why the field sobriety test should have been suppressed, nor is there a basis for that in the record. And as this court has noted in Cardone v. Cardone and other cases, it's the appellant's job to develop those arguments, not the responsibility of this court to read them out. But even assuming that there was some basis, which has been unstated, as to why those field sobriety tests should have been suppressed, Mr. Stark seems to be arguing that, as in this court's case and this court's recent decision in State v. Hop, in which without field sobriety tests that were suppressed, there was not sufficient probable cause, that a similar thing would have occurred here if a motion had been made. Now, the issue here is that there is still more evidence here for probable cause than there was in Hop. In Hop, the offense took place much earlier in the evening. There was an admission to having 2 scotches with dinner as opposed to 3 or 4 shots of tequila at the bar. And then, in addition, there was a traffic violation, critically here, that there wasn't in Hop, which was a case involving an OVI checkpoint. And so, in addition to not showing that not making this motion was a deficiency, Mr. Starks still has not shown that there's a reasonable probability that the outcome of the trial would have been different if such a motion had been made. And so, in addition, there could have been additionally other evidence in support of probable cause that could have come up in a motion, in a suppression hearing. There was a portable breath test that was taken at the scene that was not discussed at trial by...
Is this part of the record, though?
It was not part of the record.
Not part of the record on appeal?
No,
Okay.
no. But there are...
No, we're limited to what's on the
Sure.
record, so.
Sure, but based on the same argument from before, there is potentially other evidence that could have come out in a suppression hearing that may not have. And so for those reasons, both Mr. Starks has not shown that there were deficiencies in not making the motion, both regarding the initial stop and the OVI arrest, and has not shown that there's a reasonable probability that those motions would have led to a different outcome. And so for those reasons, we respectfully request that the assignment of error be overruled and that the decisions of the trial court be affirmed. And thank you, and I'd be happy to take any questions your honors might have.
Seeing none, thank you for
Thank you.
your presentation today. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted to our website, and that